The High Court is at the apex of the judiciary in the state. At present, there are 25 High Courts in the country. Three among them have jurisdiction over more than one state. The small states and union territories do not have separate High Courts. They come under the jurisdiction of High Courts of bigger states. Composition. The High Court consists of Chief Justice and some other judges appointed by the President of India. All the High Courts do not have the same strength. In the appointment of the Chief Justice of High Court, the President consults the Chief Justice of India and the Governor of the concerned state. Other judges are also appointed according to the same procedure, except the Chief Justice of concerned High Court is also consulted. They hold the office until they attain the age of 62. Judges of one High Court can be transferred to another High Court. They can be removed through the same procedure as followed in the case of Judge of the Supreme Court. Qualification. A person to be appointed as a Judge of High Court should fulfill certain requirements or qualification. First one, he must be a citizen of India. Second one, must have held a judicial office for at least 10 years or have been an advocate of the High Court for at least 10 years in any High Court. Powers of the High Court. Original jurisdiction. The original jurisdiction extends to those cases which High Court has authority to hear and decide in the first instance. It has the power to issue the direction, orders including the writs to any person, authority and any government within its jurisdiction against the violation of the fundamental rights of citizens. Second one, appellate jurisdiction. It includes the power to hear appeals about civil and criminal cases against the decision of all lower courts in the state. The third one, the High Court can review or the change the decision taken by the subordinate courts of that district. And also they having the power to transfer the case from one court to the another court. The fourth one, High Court can have the full control over the subordinate courts in the state. And number 5, it has the revisory jurisdiction. The High Court may call for the record of any case which has been decided by the subordinate court in the state if the High Court feels that the subordinate court has exercised a jurisdiction is not vested in it or has acted wrongly. It may make such order in the case as it deems to fit. And the last one, this High Court will have the very clear role, that is court of record. All the records will be saved in the High Court. These records will serve as a reference for the lower court in the future cases. Writs. Both the Supreme Court and the High Court are empowered by the Constitution of India to issue the writs for safeguarding our fundamental rights. What is a writ? A writ is a legal instrument to enforce the obedience to the orders of a court. Now we can study about the 5 important writs can be issued by Supreme Court as well as High Courts of India. The first one, writ of habeas corpus. Habeas corpus is a Latin term which means you may have the body. It provides the remedy for a person who has been unlawfully held in prison or in a police custody. The Supreme Court and the High Court command the detaining authority to bring the prisoner into the court to explain why he is being held. If the cause is insufficient, the prisoner is at once unconditionally released. Second one, mandamus. The Latin term mandamus means we command. The purpose of the writ is to compel an inferior court or individual to perform their duty. The duty must be imposed by the Constitution or some law. Third one, prohibition. The writ of prohibition is issued to prevent an inferior court from exercising the powers which it is not legally vested with the court. The Supreme Court and High Court direct the inferior court to keep within the limits of their jurisdiction. The fourth one, certiorari. The term certiorari means to be informed of what is going on. By this writ, the lower court is asked to hand over the record of a particular case to the higher court. The last one, writ of quo warranto. This writ is directed against the person who is wrongfully holding an office. The office must be public office or an office in the public nature. The writ calls upon the person to show under what authority he holds the office. If the court decides the person concerned is holding that office illegally, it may declare that office to be the vacant one.